Again, I'd like to provide a brief introduction to Des & Shira and myself. Since its establishment in 1992, Des & Shira & Associates has grown into Asia's one most versatile consultancies dealing with legal issues, tax issues, accounting, HR, payroll, and IT services, with operational offices across China, Hong Kong, India, Singapore, and Vietnam. I'm a senior associate in Des & Shira & Associates' Guangzhou office, and today I'm here to talk to you about labor disputes in China and how to avoid them. Essentially, what we will be covering in this webinar are the best practices that companies can implement to add extra layers of protection against disputes. Before we get started, I'd also like to point out that during this webinar, you'll have the opportunity to ask questions, and I'll have a Q&A section at the end of the presentation. To do this, just bring up the question box on your webinar tab, type in your question, and send. While I might not be able to get through all of the questions in our allotted time, if I do not answer your question in the webinar, I'll follow up privately with a response after the session. Okay, today we're going to be talking about the following topics. We're going to start with the common error caused by companies. We'll be talking about employment contracts, staff handbooks, working hours, attendance, leave, performance assessment, termination of contracts, and disciplinary measures. On our first slide today, we're going to be talking about common errors made by companies, and we'll specifically be talking about hiring too quickly before establishing rules and standards. And before we get into the meat of this, I just want to talk about HR at a glance in China. There are several tabs here, and each of those is a topic that I'll just quickly touch on. Mandatory written contracts. All employees in China must be given a written contract within 1 month of hiring. If not, the employee is entitled to double salary. And this is very common amongst newly established companies who rush to hire without issuing contracts. The range of probation period is the range of legitimate grounds for dismissing an employee is considerably wider during his or her probation period. The employer may also only pay 80% of the employee's contractual salary during this time. There are regional variations. National laws in China are often intentionally broad and vague, leaving a lot of room for local interpretation or additional legislation. Regulations and practices differ per city on issues such as minimum wages, work visa policy, social security contributions, and maternity leave. Representative offices are seen as the simplest form of foreign investment vehicles into China. The RO, however, is not permitted to directly hire staff in China. Instead, they need to use dispatch agencies, the largest of which is the Foreign Enterprise Service Corporation, or FESCO. Leave during the first year of employment. Employees are not entitled to any minimum leave during the first year of employment, except those during major holidays such as Chinese New Year or National Day. There's no at-will termination. This is a very popular concept in the United States. Terminating employees in China is both very difficult and expensive. Employees may resign under 30 days notice, but for employers, there are limited grounds for terminating an employee before his or her contract has come to an end. Contracts can only be extended a maximum of 2 times. After an employee finishes his or her second contract with your company, they must be offered an open-ended contract as the third. Such no fixed contract terms can only be terminated if there is grounds for dismissal. And severance payments are mandated by law. In practice, severance payments are actually even higher than the law prescribes and can comprise of a significant part of the overall HR costs. Many managers in new Chinese enterprises are extremely focused on starting business operations as soon as possible and are eager to hire staff such as managers and subordinates. It is a fact that good, qualified people are hard to find, and when new managers finally do find the appropriate worker, they are often overjoyed and rush through the employment process. Before hiring, it is very important to set employee standards, and key provisions in employment contracts are often overlooked, such as proper overtime rules, codes of conduct, performance standards, promotion standards, KPIs. And later, a misunderstanding may arise between the employer and the employee. For example, if the employee is performing poorly or the employee feels that they deserve a raise. If any of the above-mentioned provisions have not been clearly communicated, witnessed, and recorded, then the employer has no legal grounds to stand on. In Chinese labor disputes, the burden of proof always lies with the employer, and this will be stressed again during my presentation. So it is very important to take the time to properly issue employment contracts, to set standards, clearly communicate the internal rules with all employees, to keep detailed records of all interactions with employees. This might seem cumbersome and bureaucratic, but it is the only way to ensure that you are legally protected in the event of a common labor dispute with an employee. Now, when I say common labor dispute, I generally mean one of the four following. Disputes mainly arise from working time or overtime payments, bonus payments, any reasons for termination of the employment contract, and compensation for an employee when terminating the contract. So speaking of contracts, we're now going to move on to written contracts, which have been mandatory in China since 2008, except for part-time employment contracts. There are serious consequences for not concluding a written labor contract. And while the vast majority of foreign companies always prefer, they actually always prepare proper contracts, they often file them incorrectly and then cannot locate them in times of need. So filing is just as important. The employment contract must clearly state the ID of the two parties involved, the addresses of both parties, including the legal representative, names of the employee, the terms of the contract, the job description and the workplace, working time, leaves. It must also mention whether the contract is a fixed term, open term, or a project-based. And again, if you offer an employee two fixed-term contracts under Chinese employment law, you are legally obligated to issue a permanent contract upon the employee's completion of the second fixed-term contract. These are also worth including into the contract are references to the staff handbook or employee handbook, mention of violations of any of the regulations, non-competition clauses, and non-disclosure clauses. The staff handbook is essentially a guideline on employer and employee rights, and for companies that are over a certain size, we generally like to think over 10 employees, they should implement a staff handbook. It should be essentially a practical source of information for both the employer and the employee, and it is an extremely convenient way to communicate internal rules, codes of conduct, work standards, and any other rules that the company might have. So an ideal staff handbook is both comprehensive but not excessively bland, and it must be written in an appropriate language that is understood by both the employer and the employee. This means in China that you will need to have your staff handbook in both Chinese and English, even though the Chinese version is the one that is that holds preference in courts if any cases are brought. The staff handbook should contain the company codes of conduct, any internal rules, guidelines, or rights of both parties, any relevant KPIs and performance standards and assessment information, non-disclosure agreements, information about working environments, working hours, overtime rules, remuneration rules, social welfare, bonus rules, information about paid annual leave. It also should include behavior standards, disciplinary procedures, training information, workplace security rules, and any other specific rules related to that industry. For example, if a manufacturing company, they should put in safety standards or hygiene standards if they manufacture food. If any changes are to be made to the staff handbook, the staff must be notified and given a chance to raise concerns with the proposed changes. The best method to do this is to hold a meeting to tell the staff about the changes, getting everybody to sign the attendance sheet and then file the attendance sheet in a secure place. And everything must be signed, witnessed, and properly filed. We can use a recent case that Desmond Shira had as an example to show the efficiency and the effectiveness of the staff handbook. A manager who was dismissed brought arbitration against the employer and claimed severance payments as well as an additional 1 month's salary due to be fired without 30 days written notice. the employer claimed that he was in serious violation of company rules due to signing an agreement with a supplier run by a relative and not informing the company in advance. The arbitration committee ruled in favor of the employer due to a signed staff handbook indicating that the manager in question was well aware of this internal policy. Now, had there been no staff handbook, the dismissal could very well have been deemed unfair and the company would have been liable for severance compensation. So it is very important that all employees sign a copy of the handbook, and any changes made to the handbook should be detailed to every employee and further signed and filed. Okay, moving on to our next section, which is working hours, overtime, and annual leave. In China, the standard labor regulations are that an employee cannot work more than 8 hours a day and no more than 40 hours per week. They also must have 1 day of rest per week. Overtime cannot exceed 3 hours per day, with a maximum of 36 hours per month, which is about 9 hours per week. Overtime is equal to 150% of normal salary, and overtime on rest days, such as weekends, is equal to 200% of the normal salary. There are other types of accepted working hour systems that are allowed in China, such as the comprehensive working hour system and the flexible working hour system. These two systems are extremely similar, with only a couple of minor differences. Under the comprehensive working hour system, the employer and the employee determine how many hours should be worked in the labor contract, and it is only if this amount is exceeded that overtime would have to be paid. Under the flexible working hour system, an employer may require certain staff, such as high-ranking managerial staff and sales staff, to work in excess of 40 hours per week without paying overtime compensation. However, there are local rules, and local governments would provide specific provisions to the overtime allowed in each different region. For overtime approval, in order to effectively manage staff and avoid disputes about working hours and overtime, it is advised that managers or companies keep attendance records. Usually a simple piece of paper with records of employees' arrival and departure time and employee signatures will suffice. Some companies go so far as to have fingerprint scanners or face scanners. These then digitally record the employees' log-in and log-out times. This is an easy way to prove if an employee did or did not work overtime. Employers, they can also implement an overtime approval procedure that requires employees who want to work overtime. They need to fill out an application, which is then submitted to management beforehand and must be approved before the employee can stay for overtime. Employers are also advised to include definition of absences in the employee handbook, such as absence without approval or absence without proper procedure. It's also very important that the employer states that absence from work without proper approval is a serious violation of company policy or something to this effect in the staff handbook. This gives the employer further legal basis to fire an employee who is frequently absent. Keeping careful records of attendance makes it much easier to fire such employees who are frequently late or absent, but the burden of proof, again, is always on the employer. Paid annual leave for employees, and this includes dispatched employees in China, is regulated by the State Council Order number 514, or the Regulations on Paid Annual Leave of Employees. Employees who have worked at a company for one continuous year are entitled to 5 days annual leave. Thus, the employers do not have to give leave to any of the employees who have not yet worked for 1 full year. Between 10 and 20 years, the leave allowed is 10 days, and over 20 years, the minimum leave allowed is 15 days. In the case where an employee has not taken all of their paid annual leave in that specific year and does not agree to carry over the untaken leave to the next year, the employer must compensate this employee with 200% of the employee's average daily wage for each of the unused annual leave days, in addition to their regular daily wage. Many foreign companies in China provide additional annual leave for their employees as a benefit, and as this is part of their internal policies and not specific to Chinese labor laws, the employers have the right to make certain changes regarding compensation schemes for untaken leave. So if you have an employee, how do you assess and what steps need to be taken to determine whether this employee is entitled to pass their probation or if they're entitled to a bonus? Performance assessments are not only an effective way to ensure that employees are performing at an acceptable caliber, they also provide legal grounds for termination of employee contracts. It's advised that employers have regularly scheduled assessments and include assessment info in the employee handbook. Assessments should be performed on schedule, and the meeting minutes should be recorded, signed, and filed properly. Examples of assessment types are probation period assessments, which can be the basis for either passing or failing probation, annual assessments, which has specific assessment standards and the results of which can result in either a position change or a salary change. There should also be an assessment for the annual bonus. Some employers include in the employee handbook that bonuses are only given on based on specific circumstances, such as the profitability of a company or the performance of an employee. Or they can include a statement such as paying bonuses is at the discretion of the employer, but additional proof, such as a record of performance evaluations, records of employees' KPIs, these are also very helpful to legally justify withholding a bonus. So for the assessment procedure, the slides on the screen show the general procedures that should be taken. First of all, the assessment should be formulated by the company, acknowledged by the employees, included as an appendix to the employee handbook, scheduled in advance, and recorded afterwards. And all individual KPIs and following performance evaluations shall be recorded in writing and filed to the employee's personal records. So what happens if your employee is not doing well, but you don't want to fire them? Well, good performance assessment records also make it easier to perform a unilateral position adjustment or a demotion without any negative legal consequences. The employee handbook should contain a definition of incompetence that is both measurable and objective, and it would also benefit the company if they considered having specific salary levels for different positions, so that if somebody was to get a demotion, their salary can be adjusted to meet that level. When firing an employee in China, the employer generally has two options. They can choose to make a severance payment to the employee and immediately terminate the employment contract, or they can give the employee 30 days notice before the contract is officially terminated. The most common reason that an employer will choose to end the employment contract is incompetence on part of the employee. It is important to remember that incompetence must be proven by the employer. Otherwise, the employer will be considered as illegally terminating the employment contract, and in the event of a legal dispute, again, the burden of proof is always on the employer. Some reasons for termination are that the employee is deemed to be unqualified during the probation period, that there's corruption on part of the employee. Corruption could include working for a conflicting company while still under employment contract. The employee was hired on fraud based on part of the employee. They're being criminally investigated, or the employee seriously violates company policies or internal rules as stated in the handbook. Now, according to China's labor contract law, an employer can terminate the labor contract with an employee within the period of probation if the employee cannot satisfy the employment requirements. However, the employer is obliged to provide relevant evidence to justify the termination, including what the employment requirements are, the employee's acknowledgement of these requirements, and an assessment of the employee's performance during the probationary period. The employer must make the employment requirements clear to the employee during the recruitment process. If a court or arbitration committee considers the evidence of the employer to be insufficient, the employer might be required to pay compensation to the employee, and the termination can be overturned. Okay, so moving from termination, we're going to talk a little bit about mass layoffs just for a couple of slides. A mass layoff might be unavoidable for many companies that are facing declining demand and rising business costs. However, implementing mass layoffs in China, it's a complicated procedure that requires adherence to strict procedures and, under some conditions, explicit government approval. When restructuring a company at such a large scale, employers must take caution of government regulations and the rights of their workers. Failure to satisfy regulations and procedures when carrying out mass layoffs can lead to a rejection from the government, workplace disruptions, and costly labor disputes that companies can ill afford when already in such a fragile fiscal state. So legally speaking, an economic redundancy is when an employer lays off 20 or more employees or 10% of its total number of employees. In order to protect the workers' rights, a company can only carry out mass layoffs under specific circumstances. According to the labor contract law of the People's Republic of China, these circumstances are that the company undergoes restructuring pursuant to the provisions of bankruptcy law, the company has serious difficulties in production and business, the company undergoes a change of production, significant technological reform, or change of mode of operation, and also if the objective economic circumstances for which the conclusion of a labor contract is based have undergone significant changes, and the result is that the labor contract can no longer be performed. So the procedure for a mass layoff, if a company qualifies for economic redundancy or mass layoff, it must follow a particular procedure to downsize lawfully. And as long as the steps mentioned in the slide are satisfied, they can proceed with the mass layoff. So first of all, they must announce the situation to the relevant labor union or all staff 30 days in advance of the planned downsizing. They must seek the opinion of the labor union or employees. They must develop a proper scheme for enacting the redundancy. They must then report the redundancy scheme to the government labor administrative authorities, and then announce the formal scheme of economic redundancy to all staff, terminate labor contracts with laid off staff, and then settle their severance payments. And there are some considerations to be made when conducting a mass layoff. When engaging in such an economic redundancy, staff cannot be laid off indiscriminately. Special considerations must be paid to vulnerable workers who retain additional government protection, such as pregnant or injured employees. For example, Article 42 of the Labour Contract Law of the PRC regulates that an employer cannot rescind a labour contract with an employee where that worker has contracted an occupational illness or suffered an injury while working for the employer and is confirmed to have lost their labour capability either wholly or partially. In this case, the injured or otherwise indisposed worker's contract cannot be rescinded during the mass layoff. So awareness of the makeup of company staff and their legal rights when developing a layoff scheme facilitates a smoother and more amicable transitional process. Now, while such economic redundancies are not pleasant, they're certainly not a pleasant approach to scaling down a struggling business. It is essential to be prepared for this in case the need arises. So employers should be prudent when planning a mass layoff to avoid rejection from the government or any contentious labor disputes. Further, companies would actually be wise to develop programs to help laid off employees transition to new jobs and actually insulate them from the shock of unemployment. Employers must be mindful of strategies to lessen the impact of mass layoffs on both the company's bottom line and the well-being of their employees in order to successfully weather any new challenging economic periods. So while we're still on the topic of dismissing employees, generally speaking, disciplinary measures must be taken first before an employee can be fired. So not only must disciplinary measures must be taken, but they also must be recorded to ensure that you have given the employee a fair opportunity to correct their behavior. You need to make sure that any serious violations of company rules are recorded, witnessed, and filed correctly in the employee's personnel file. you can think of this as building your case or collecting evidence so that later you have the justification to fire an employee if their performance does not improve. The most common form of disciplinary procedures is to first issue an oral warning, followed by an official written warning if the employee's behavior does not change. And in order to make an oral warning official and legally solid, meeting minutes must be taken, recorded, witnessed, and signed by all the relevant parties. The written warning can take the form of a letter or email addressed to the employee, and if the employee refuses to accept the letter, this also must be witnessed, recorded, and filed appropriately. The employee must also be offered job training before they can be fired or demoted. Make sure to keep a record of any kind of retraining that is done, and this is proof that you actually attempted to help your employee improve at their job, but their performance still remained unsatisfactory and you had no further choice but to dismiss them. Keeping careful records of attendance also makes it easier to fire an employee who is frequently late or absent. And one more time, the burden of proof is again on the employer. So it is important that when you are terminating an employee's contract, that it be done in accordance with the Chinese government's regulations. The Ministry of Human Resources and Social Security has issued provisions for labor and social security offences committed by employers to actually be made public. So the law will come into effect on the 1st of January 2017, and it will apply to all companies operating in China that commit significant violations, and will serve as, well, at least it intends to serve as a powerful deterrent to companies who are not compliant with China's labor regulations. So what kind of violations will be published? Any kind of reduction or failure to pay employees remuneration without reason, failure of payment or enrollment in social insurance premiums, violation of working hours or holiday and leave requirements, violation of special provisions for female or underage employees, violation of child labor laws, and other labor violations that have a serious negative consequence on society. The full name of the employer, the address, social credit code, and registration number, and even the name of the legal representative will be made public by newspapers, magazines, television, and any other media outlet at county level. It will also be published on the Ministry's Administration Department's online portal, and will be included on an employer's integrity and legal compliance file, entered into the credit system of the ministry, and shared with other social organizations and government departments. Now, anything to do with state security, trade secrecy, or personal information, thankfully, will not be made public. However, if an employer disagrees with the grounds of accusation, they may submit an application for review. The Ministry of Human Resources and Social Security will process the application and process the objection within 15 days. And the objection, if it's found to be valid, correction to the announcements will be made within 10 working days. So this has a serious implication if they incorrectly publish information. It will take them the better part of a month before they're able to actually take that information down. Okay, so just to have a quick conclusion on what we've talked about in this webinar, it's very important, extremely important, to implement a proper HR structure even before hiring. New companies that set up often make the mistake of not implementing sign-in rules, attendance rules, leave, handbooks, contracts. These must be done before hiring. Also, have every single employee sign a contract within 30 days of them working or coming on board in the company. Otherwise, for every month that they work without a signed contract, they'll be entitled to double compensation. It is advisable to draft a staff handbook. It's also advisable to detail requirements on working hours, attendance, leave. It's very important to record performance assessments, bonus assessments, training, retraining of employees, and most importantly, make sure that you discipline your employees before you terminate them. Okay, so that concludes the main structure of our webinar today. We're now going to move on to our questions and answers section. Again, if you have any questions for us, you can type them into your question box, and I'll do what I can to answer these questions in our allotted time. I have about 5 minutes left before we must conclude this webinar. So I'm going to move on to our first question. Question here is, how do I protect confidential information that employees come across during their employment? Okay, how to protect confidential information. Okay, this is quite a good question. First of all, it is imperative to have confidentiality or non-disclosure clauses in your contract. This protects your company's IP, and it offers you the ability to unilaterally dismiss an employee that is in violation. Also, you can include a clause that prohibits your employees from taking up employment in a competing company after their employment with your company has been concluded. So China allows you to further protect your company and your IP by essentially not allowing them to work for a competing company after they finish up with you. However, you must pay them continuously after their employment is concluded. There might be some regional variations, but in Guangzhou, for example, the minimum amount to be paid is 30% of their average gross salary over the last 12 months, and this can be done up to a maximum of 2 years. So this is an important way for employees, for companies who wish to keep their trade secrets. Okay, we have another question here. When first hiring an employee, what is the maximum length of probation? Okay, right, the probation period is actually dependent on the terms of the contract. So if a contract is 3 months to 1 year in length, the probation period will be 1 month. If the contract is 1 year to 3 years in length, the probation period will be 2 months. And if the contract is more than 3 months, then the probationary period will be 6 months. If there's an open term contract, the probation period is also 6 months. Okay, another question I have here is, how long after a dispute occurs can a plaintiff apply for arbitration? I can give a very short answer to that. 1 year. Essentially, the labor dispute mediation and arbitration law, it actually stipulates that there's a time limit on how long before the dispute becomes void before an employee can make the application to the arbitration committee. And that is 1 year, within 1 year of the dispute arising. I have received a question about handbooks for companies that have less than 10 employees. The question was, are they still required for an employee, for a company that has less than 10 employees? The staff handbook is not actually really required. It's more of an additional form of defense that a company can have. And we generally say 10 employees would be a minimum amount to have before implementing it, but you can, if you feel you need to implement a staff handbook with 4, 5, 6 employees, you have all the right to do that. There's nothing stopping you from doing that. Another question is, if all employees are native English speakers, does the written contract need to be in Chinese? The short answer is yes. All contracts need to be in Chinese. They are only valid in Chinese. I've got a question here on, are there any special procedures for terminating senior management? Okay, this is a good question. Firing senior managers, it's actually a very complicated process in China. It requires quite a thorough understanding of the country's laws. Even before a decision to fire somebody has been made, it's better to proactively prevent risks to your HR by implementing, let's say, a staff handbook, or by implementing attendance records, these kind of assessments as well. So if an employer wishes to terminate a contract of a senior manager, there are a set of specified reasons for them to be able to do so. These include mainly that the employee or senior manager, they materially breach the employee or the company's rules or regulations. There's gross negligence on behalf of the employee that causes substantial damage to the employer, and the employee or senior manager, has criminal liability or is being investigated by the criminal department. These causes are stipulated in Article 39 of the PRC's labour contract law. If the case is taken to labour arbitration and the employer is found to have wrongfully terminated the employee can either demand their old job back or demand compensation that is double to the rate of normal lawful termination. Accordingly, a company looking to fire senior management should expect to have a strong show of evidence in support of their decision to terminate. Again, keeping records is the best thing that you can possibly do. I have another question here on if the annual leave is different between normal contract and dispatched employee. Generally speaking, the rules for employees the rules for annual leave are generally the same between dispatched employees and normal employees. Think about the way representative offices hire their employees. They must be hired through a dispatch agency, and they're still entitled to take annual leave or a certain amount of annual leave. So it's the same if it's dispatched or if it's with the company. I have a question here as well saying, during termination of the contract, if any agreement between the employer and employee, not according to labour law, but mutual agreement is acceptable. Technically, yes, a mutual agreement can be used. I can give you an example of when it would be best used would be, let's say, if a representative office is changing to a wholly foreign-owned entity. The representative office is going to be shutting down and must essentially fire all their employees. But let's say they want to rehire all these employees through the WFI. They can actually set up a mutual agreement that, as long as everybody agrees to it and is signed and is not, well, too outside the law, then it is possible. For example, if they were to sign an agreement that said the employees do not wish to take any severance payment from the representative office, but the wholly foreign-owned entity will recognize their time spent in the RO. Another question I have here is the employment contract. Does it have to be on a legal paper or just normal paper with the company's signature? There's no special type of paper that's needed. Generally, it would be good to have it on company company ink or company paper, but it will need to be stamped and will need to be chopped by the company. Actually, on to chops, I've got a question here on chops as well. What happens if my company chop has been taken? Well, that's quite a bad situation that you're in. Chinese commercial law attaches a very high legal importance to the company chop. Its use is an absolute necessity in many business operations. And there have been cases where outgoing employees have actually taken the company seal to effectively paralyze the company or take it hostage. It's an extraordinarily difficult situation to get out of, especially if the perpetrator was once the company's legal representative. So if a company seal has been lost or stolen, then the company would need to make an announcement as soon as possible in an official journal or an official business newspaper, and then it would be possible to cancel the seal and register a new one. So in order to avoid this, companies should set up internal application processes for using the company chops. For example, staff members wishing to use it must submit a request to management clearly stating the reason for using the chop. Okay, I have another question. If employees have split contracts between Hong Kong and China, which employment law would take precedence in a termination situation? If the employee is working in China, they need to have an employment contract. So it doesn't matter, like they can have another contract with the HQ, but regarding their employment in China, only the Chinese labor contract will take precedence. Always, 100% of the time, the Chinese labor contract will take precedence. If they're working in China, if they make their money and pay tax, pay social insurance in China. If an employee disagrees to the staff handbook, if they disagree to sign the staff handbook, can the company still terminate an employee if they violate the discipline set in the handbook? Generally speaking, yes, they can. If the employee is aware of the rules in the staff handbook, even though they do not sign it. The signatures are just there to show that they've read the staff handbook, really. The signatures are essential, but if you have an employee who says, oh, I read the staff handbook, but I do not want to sign it, and then breaks one of the rules in it, you have a record of them saying, I read the handbook and did not sign it. So unless the rule is completely arbitrary and unrealistic, then it's still okay to dismiss them using the staff handbook. Okay, I have another question here. In the case of a pregnant employee, should they pay all the salary or less? Also, how many months maximum a woman cannot work before and after pregnancy? Okay, so pregnant employees are, well, they're quite difficult to deal with at times. We have Chinese employees contribute to maternity, so they actually receive their maternity benefit. There's a set amount issued by the Social Insurance Bureau about how much they pay during maternity leave, and usually in China there are regional variations on how many months that they can work or what their maternity leave is. It's usually 180 days, but you'll need to double check that with your local bureau. And then the other question is, how many months maximum can the woman not work before and after pregnancy? That's there is no real set rules. It's usually I think it's the last trimester, to be honest, but it would depend if there are, let's say, complications, if there are twins. People who have give birth to twins are entitled to more days off than people who aren't. So there are various factors that are there. Another question, does every employee holding a working permit from our company need to be included in the social insurance? There's two questions here. First of all, every employee that is working in your company must have a working permit, and they must pay social insurance if they're in your company. Now, I believe in Shanghai, it's voluntary for foreign employees, but in other cities, like Guangzhou, for example, it's mandatory. Actually, I read a statistic recently that said that out of all the legally working foreigners in Guangzhou, only 400 of them pay social insurance. So it's very rare for companies to do this, but they must pay social insurance for their employees. Regarding freelancers, technically speaking, freelancers are not regulated so much under the Chinese law, and freelance contracts are generally used for like translators or let's say a house cleaner or something like that. So they don't follow the same rules. Like, for example, if you were to terminate a freelance contract, you would not need to pay you would not need to pay severance unless it's agreed within the employment contract. So generally speaking, freelancers are under different regulations than normal employees. But if you have an employee, a foreign employee working in your company, they must have a residence permit, a working permit, they must pay IIT, and they must pay social insurance. Is there any limitation about the number of working hours per week or month for managers? I believe they would fall under the same the category as there's a maximum of 40 hours, but then there would be internal overtime rules that companies would have. But generally speaking, under the law, if you are to implement a system where it allows somebody to work more overtime hours, it needs to be approved by the Labor Bureau before they can sign the contract. Okay, another question. Is there any law that refers on raising salary after the probation period, or can that be defined in the contract? Okay, good question. You are entitled to pay 80% of their total salary during the probation period, and that is up to the company. So the company can decide whether they pay the employee full or whether they pay the employee 80%, but the minimum you can pay them is 80% during the probation period, and after the probation period is finished, then you must raise the salary to the normal amount. Okay, I think we have a couple more questions. Okay, one that I have here is, what happens if I fire somebody during probation without giving a proper reason? That's actually a very good question. Okay, so many employers in China, they already know that the labor contract of an employee can be dissolved at any time during the probationary period. However, most are actually unaware that the restrictions governing this termination procedure. So according to China's labor laws, the ability to terminate a labor contract during the probationary period is limited to the specific circumstances where it is proved on the expiry of the probationary period that a worker has failed to meet the employment requirements. So in practice, this rule is endowed by law as a right for the worker, and it is the employer's burden to prove that the employee has failed to meet the employment requirements. If the employer intends to dissolve the labor contract at all during the probationary period, they must prove this. So according to China's labor contract law, the employer can actually terminate the labor contract within the period of probation if the employee cannot satisfy the employment requirements. However, it is the employer's obligation to provide relevant evidence to essentially justify this termination, including what the company's employment requirements are. They need to show that the employee actually acknowledged these requirements and that the assessment of the employee's performance during the probationary period and show that he was not a satisfactory employee. They must also make the employment requirements clear to the employee during the recruitment process. If a court or arbitration committee actually considers the evidence of the employer to be insufficient, then the employer might be required to actually pay compensation to the employee, and the termination can actually be reversed. It can be overturned. So from a legal perspective, there are no actual specific regulations on the standards and principles of employment requirements. So it's good to have the definition of what these employment requirements are to be determined by the employer themselves. But of course, this has to be within the scope of law and based on the company's practical situation. Does an increase of salary within the same contract, same dates, considered an additional contract? Quick answer: no, it does not. The same applies for, let's say, promotion. They don't actually need to sign a new labor contract with the company. They can do that. I have a question about unions or union organizations in the company, but I'm not sure what the question is. Do you have any? Are there any other further questions? Hiring a foreigner during the probation period. The employer can have a business visa, it must have a working visa. Okay, that's a good question. So when you're hiring a foreigner, like whether or not they need a working visa or working permit during their probation period, and the answer is yes, they do. Normally speaking, you sign the contract at the start of your employment, and the probationary period runs then after you sign the contract. So from the date of signing the contract, you must have a working permit, residence permit. So the applications must be made during that time. But then if you dismiss the employee, you can then cancel the working permit after the employee has been terminated. Okay, I think we have time for one more question. Does an employee after maternity leave have the right to work less hours for nursing the baby in the first year? Generally speaking, yes, they are entitled to have, they can come back on sort of a part-time basis. Many new mothers do this because it actually gets them more money. They don't then rely on their maternity benefit from the company. They actually start getting their salary again. So some might come in. There's no general procedures for it. There would be regional variations, but you can determine this in your staff handbook as well if needed. And do we have to have a union? Manufacturing company with 250 workers. Unions in China are they're a very gray area. Generally speaking, there would be representatives from the employees. It would be good. It's an easier way to communicate with your employees. And if there are, let's say, staff handbook, for example, needs to be changed. If the staff handbook needs to be changed, and if Let's say, for example, there's an issue or an employee gets injured, having a union to represent the employee can help, but it's not mandatory, it's not written into the law. And I think you got one more question. This is quite a strange question. How to deal with an employee who got pregnant in the probation period? Well, the rules still apply to pregnant women. Actually, that's a very gray area. Generally speaking, for a pregnant woman, they're untouchable when it comes to firing, unless they created like serious violations or burn the company down or something. Then there's not really much that can be done. We actually have come across a case before where during a mass layoff, it was announced that the employees were going to be dismissed, and one employee came to the employer and said that she was pregnant. And there's a rumor going around that the woman wasn't actually pregnant, but during the time it took to actually implement the mass layoff, she got pregnant and then was not able to be fired from the company. So China protects its pregnant women and its sick and disabled employees. So it would be very difficult to fire a pregnant employee. Okay, I think that's actually all we have time for at the moment. I'd like to thank everybody for joining. If I didn't get around to your questions, I have them listed here, and I'll be able to answer you through email. Please remember to download the slides, and you can contact me through email if you have any further questions. We're always available to talk more. Thank you very much for listening, and have a good day. Thank you.